Hi everybody. Just another case update for you today. I wanted to talk about the case of X&Y, which is about revocation of adoption orders. And this is a 2024 judgment that came out literally just a couple of weeks ago during April of 2024. Just bear with me and I'm going to pop the presentation onto the page. So as many of you will know, and for those who don't, you will in a moment, when a court in the UK wants to make an adoption order, they have to be satisfied that no other order is appropriate for that child. So basically, it's an order of last resort. If you can keep a child within their birth family, then that is the most effective and best solution for that child, as long as they can be cared for safely. But if they can't be cared for safely in that environment, then the next best thing might be placement with relatives or with family friends, so that they stay kind of in the wider birth family. Only where all of those options have been considered and aren't appropriate would you consider adoption. There are two options really. You could either go down the adoption route or long-term foster care. Now, for young children, there are many downsides to being in long-term foster care. That ranges from placements not being always stable and long-term, so they might move around, to the fact that they are considered a looked after child for pretty much, the majority of their childhood. And they've always got social work involvement. And they don't have that sense of belonging to one family. So they look at adoption as an opportunity for that child to have their forever home and their forever family. Sometimes things don't work out quite how they plan. And this case is one of those, unfortunately. So what happened? Well, let's look at the dates of the judgment first. So there was a hearing on the 6th of March of this year. And then the judgment was handed down on the 24th of April. And it relates to two children, X, who was 17 years old at the time, and Y, who was 16 years old. So these are children who, have almost reached adulthood, but you will understand why this application came about when we go through the background. So we'll have a look at the background first before we look at what the judgment says. So in this particular case, we've got a number of players, and they were all given, as in every case in the UK that deals with children, they were given acronyms, I suppose, to refer to them, because they cannot publish information which might identify the child. So even though the parents are adults, if you publish their name, then you can identify who the child is by a roundabout means, so to speak. So we've got BM, who is the birth mum of X and Y. We've got AM, who is the adopted mum. And we've got BFX, which is birth father of X. And then we've got X and Y, who are the children. As I say, X was 17 at the time of the hearing, and Y was 16 at the time of the hearing. And they were both considered something that's called Gillick competent, which means essentially that they are old enough and understand enough to be able to participate in the proceedings as their own individual person. And so instead of having just the children's guardian looking after their rights, they can have their own separate representation. This particular application was made by the adopted mum, so AM, and that was an application to revoke the adoption orders because the adoptive placement had broken down, essentially. Both X and Y, the two children, two sisters, supported the application. They also made an application to allow a change of their names back to the birth mother's surname. So when you're adopted, you take on your adopted parent's name. The law basically says that you are put in a position that you are the adoptive parent's child, as though legally you had always been their child. So that means that your birth certificate is redone, and you are considered solely a child of the adoptive parents. And it's designed to be forever. It's designed to be a permanent change. Now, the various arguments that were made in support by AM were this: that the court had a power under what's called the inherent jurisdiction of the High Court to revoke the order, or alternatively, they had a power under section 31F6 of the Matrimonial and Family Proceedings Act of 1984, which gives the court power to vary, suspend, rescind, or revive any order made by it. And that makes great sense in overall terms, but where there is already a statutory scheme, and we'll see later in the judgment, if there is a statutory scheme that deals with one particular area, inherent jurisdiction doesn't apply. And where there is a statutory scheme that looks at when orders can be revoked, you can't then run roughshod over it with some other piece of legislation that's got some vague general power set out within it. So what happened in this case? What was the background? So care and placement orders were granted by the Family Court on the 12th of August of 2010. So a final care order basically says parents no longer have parental responsibility, and the local authority becomes the parent for that child. And it's a final order. But the placement order gives one extra step, and that says you can place these children for adoption. But it's not an adoption order. There's then a matching process that matches the child and a potential prospective adopter. And at that point, the adopter applies for an adoption order. So the local authority at that stage, even if they've already done the matching process, because they've kind of done something called twin tracking, where they basically have an understanding that this case could lead to placement orders, and they kind of are looking at potential families in the run-up. Even if they've done that, there is still another hurdle. So all the local authority can apply for is the placement order. So that was made on the 12th of August of 2010. They were then placed with AM, the adoptive mother, at ages 5 and 4 on the 6th of August 2012, and they were then adopted. So we've got a period between August of 2010 and August of 2012 when these children were in foster care, local authority foster care. And the likelihood is that they were also in foster care during the proceedings when the local authority was seeking the care order. So that could be another 6 months on top of that. So we've got 2 to 2.5 years roughly when the children were in local authority foster care, and they weren't in one individual placement. They had at least 2 placements, and during the whole of that period they had quite significant amounts of family time with their birth mother, with BM. And it's fair to say that both children struggled to settle into the adoptive placement. They had little understanding as to why they couldn't spend time with their birth family anymore when, despite being separated from them, they had done so for such a long period of time. And unfortunately, this is one of the things that happens on quite a regular basis if children are in foster care for any length of time. The longer that period and the longer the period they're separated from their family but are able to see them regularly, the harder it is to attach to an adoptive parent should they be matched with a prospective adoptive family. And that's why the government has a huge drive to make sure that family care proceedings are as short as possible. So they should be completed within 26 weeks at the maximum. But that's a maximum. And unfortunately, they regularly go over that, whereas they should actually be much shorter in many cases. And there are lots of reasons for that, but which I'm sure we'll explore at some point. Now is probably not the best time for that, but just so that you understand it, it does have a marked impact on how successful an adoptive placement might be. So how was it that they struggled to settle in? Well, they demonstrated behavioural issues, which is a very common presentation for children who have had traumatic life experiences early on. They completed therapeutic life story work. So that is explaining to children across a period of time in a therapeutic way how they've ended up where they've ended up and why. What was it that stopped their parents from being able to care for them safely? So very early on, AM, the adoptive mother, concluded that because of these difficulties and the presentation of the girls, they would benefit from spending time with their birth mother. And so she allowed them to spend time with birth mum and birth mother's extended family. And the girls ended up calling AM mummy or mum, and BM, their birth mother, mummy B, which you can imagine would be extremely confusing for children who, when they moved into this adoptive family, were 5 and 4. Their ability to grasp what was happening and why they basically had two mummies would have been very problematic for them. But that said, AM felt like once they started to see birth mum, X was much more settled. So X is the older daughter. And she felt like she was finding the missing pieces of who she was how the adoptive mother described it. BM went on to have a third child, Z, we'll call them, who lived with the maternal grandmother under what's called a special guardianship order. But Z was returned to BM's care in September of 2015. Now, imagine that you are X and Y. You're seeing your birth mother on a regular basis. Your brother or sister, your sibling, is returned to your mum's care, but you aren't. Again, extremely confusing time. BM also went on to have 2 more children with a different father. And they remained with her throughout, so they were never removed from her care. So she'd clearly got her act together to a certain extent, and certainly to a good enough extent that she was able to keep those children in her care. And then between 2017 and 2019, X wanted to live with BM and Y wanted to stay with AM. So this then gets very confusing. You've got one child who wants to stay with you as the adoptive parent. You've got the other child who wants to go and live with their birth mother. Chances are they want to stay together. So you've then got these children being pulled in every direction. In 2020, AM let BM and her children move in with her and X and Y because she was fleeing an abusive relationship during lockdown. And you can see that at that point, her heart is in the right place. She's doing the best that she can for the birth mum of her 2 adoptive daughters. Unfortunately, as is often the case, where you've got separate sets of parents, whether that be who have separated from within a relationship, or in this case where you've got foster carers and birth parents, or adoptive parents and birth parents, that relationship broke down between AM and BM. So that was in June of 2021. In July of that year, so 1 month later, Y alleged that AM, her adoptive mother, had hit her with an iPad. In August of 2021, X and Y both moved from their adoptive mother's care to a maternal birth aunt, and then at a later date moved in with their birth mother. Some point following that, between August of 21 and May of 2022, X decided that she wanted to return to the care of her adoptive mother. And unfortunately, children will very often be highly motivated to want to return to their birth parents, because children, as a matter of course, love their parents. What that does not mean is that those birth parents are best placed to look after them at any given time. But children don't perceive that element of it. They just see that they love their parents, and they believe their parents love them, and that love rules the world. And then in May of 2022, X was introduced to her birth father, so this is BFX, birth father X, and moved to live with him. Now, this is a person who hadn't been in her life for the majority of her life. But she decided that, she would take her chances, and she wanted to move in with him. And then in November of 2022, both the birth mother, BM, and the birth father of X, BFX, had positive parenting assessments. So when social workers are involved with a family and they are trying to decide whether or not a parent is safe to parent a child, they will do what's called a parenting assessment, and it's done over several sessions, and they look at all manner of different things, right from your own childhood history and your relationship history through to understanding what you know and how insightful you are about the various concerns that the local authority and the social work team have about your ability to care for the children. And it can include all sorts of things, hair strand testing to check for drugs. It can include observed family time sessions where they're looking to understand, particularly for very young children, whether you can actually physically meet the needs of the child. They often or predominantly take place in the family home, so that they can see the environment on a regular basis and understand, are you keeping it to a safe and good enough standard. So they both had positive parenting assessments. And then on the 23rd of November of 2022, the social worker recorded the following in terms of the girls' wishes and feelings, because they will always take a child's wishes and feelings into account, and particularly the older you get, the more weight is given to your wishes and feelings. Most specifically because as you get to be an older teenager, you will vote with your feet. If you put where you don't want to be, you will just go of your own accord. So they will do their best to meet the child's wishes and feelings if they can. So this is what she recorded. Y wants to stay with a birth mother. And she said this: I've never had the proper love from a mum, but my mum gave birth to me, so we have that connection. And she has just tried to make sure that the last bit of my childhood has been good. X said that she wanted to stay with her father, BFX, but still wanted to see AM, the adopted mum, more often, as she liked spending time with her. So in November of 2022, that was their wishes and feelings. Y wanted to stay with birth mother. X wanted to stay with birth father, but still see adoptive mother. And then on the 9th of February of 2023, so last year, an interim care order was made because the children were beyond parental control, essentially. So remember, they are currently the children of AM. So an interim care order was made, and then that changed to a supervision order and a child arrangements order. Now, a child arrangements order regulates who lives with whom and who sees whom and when they see them. And essentially, the court used it to regulate the existing placements. So Y with BM and X with BFX. And that gave them parental responsibility, which means that they can make decisions on a day-to-day basis about those children. Bearing in mind they were already in those parents' care, but their parental responsibility had been taken away when the children were adopted. So this gave them that parental responsibility back. Then on the 17th of March of 2023, the children's guardian, who basically is an advocate and a representative for the children, just within the court proceedings, met with Y. And at that point, she said that she wanted to stay with the birth mother, didn't want the adoptive mother, AM, to have parental responsibility for her. A month later, April 2023, the children's guardian met X, and she said that I want to stay with my birth dad and have a relationship with AM, my adoptive mum. So then the guardian needs to write their final analysis and make recommendations to the court. That's what their role is. They're independent of both the parents and of the local authority. So their role is just looking at what's best for the children. And so their analysis holds quite a lot of weight before the court. And this is what the guardian's final analysis said. Y and X were removed from parental care at a young age due to concerns in respect of Y sustaining a non-accidental physical injury, and care proceedings resulted in their being placed for adoption, this severing links to their birth family. The accounts given by Y and X suggest that they did not receive the safe, consistent and attuned care with which they required whilst they were in foster care, and those given by their adoptive mother, AM, suggest that Y and X difficult life experience have, at least in part, affected their ability to invest in their adoptive placement, which in turn has led to a breakdown of the relationship and adoption with AM. So that's what we've talked about throughout. This is a really difficult transition for children to make from birth parents to foster care, from foster care to adoptive placement. And sometimes the children aren't able to attach to those adoptive parents, and they aren't able to invest in the family as their forever family, as is designed to be the case. And then on the 24th of April of 2023, the adoptive mother, AM, applied to revoke the adoption orders. So the guardian's analysis was in relation to the initial interim care order that was made because the children were beyond parental control, and the court were trying to work out, how do we regulate these placements that the children are currently in? But after the guardian's analysis came through, AM decided to apply to revoke the adoption orders. So on the 5th of May of 2023, the court made a child arrangements order that said Y is to live with her birth mother and X is to live with her birth father. And it also granted a supervision order to the local authority for 12 months. So that would basically run until the 4th of May of 2024. A supervision order means that the local authority are able to befriend and assist a young person or child. And basically put support in place that will enable the placement to work in a safe manner. Doesn't always work, but that's the goal of a supervision order. They're made where it's clear that the children ought to be placed back with their family, but the court are not completely satisfied that no order is appropriate. So it's basically a safety net of sorts. And there is always, when a supervision order is made, the court also insists that the local authority draw up a support plan, a supervision order support plan, which sets out what the local authority are going to provide and what the parents need to do to make the placement work. So that was on the 5th of May. So bear in mind what I've just said. 5th of May 2023, X is to live with her birth father. That was the final court order. 6th of May, the next day, X moved from a birth father into a birth mum's home instead. Then, not too many months later, 17th of October 2023, X moved in to AM's home again. So she goes back to her adoptive mum and stated that she wished to continue living with her, and so we've got Y is relatively settled with a birth mum from August of 2021, but X has changed her mind and moved around left, right and centre between birth mum, birth dad and adoptive mum. So of course the judges then got to work out what to do. On the 1st of November of 2023, the judge met with Y by Teams link, and she said, I support the application to revoke the adoption order. But it was clear that X wasn't quite as settled in her opinion, so the court adjourned in November so that she could reflect on her position. She was at that point living with BM, but sometime between November and January, she moved from BM to AM again. So then she stayed with her adoptive mother for a while, and she attended college in the area. She was maintaining a life there. So it looked like she might be settling down. And on the 23rd of January of this year, 2024, X told the social worker that she would be happy either way. She didn't mind whether the adoption order was revoked or stayed in place. But Y maintained that she supported the adoption order being revoked. And she wanted to be unadopted, in her words, and to change her name back to her birth mum's surname. Now, on the 15th of February of this year, X moved from AM's care back into BM's care. And then on the 16th of February, changed her position to say that she supported the application to revoke the adoption order. She met with the judge on the 6th of March. So that's the date of the hearing. And at that point said that she supported the application for the adoption to be revoked. Now, we talked a little bit earlier about making an adoption order, which is made by the court under the Adoption and Children Act of 2002, extinguishes the parental responsibility of any person with, it's shortened in the legal world to PR. So any person with PR immediately before the order, it's extinguished. And the only piece in the Act which allows for revocation of an adoption is on legitimation. So it says, where any child adopted by one natural parent as a sole adoptive parent subsequently becomes a legitimated person on the marriage of or formation of a civil partnership by the natural parents, the court by which the adoption order was made may, on the application of any of the parties concerned, revoke the order. Well, that doesn't apply here. But Parliament clearly considered which circumstances an order for adoption could be revoked in. So it isn't the case that this piece of legislation was completely silent on when an adoption order could be revoked. They've thought about it. They've come up with one occasion, because it's supposed to be completely and utterly final. It's a permanent change to the legal status of a child and of the adoptive parents, of course, and of the birth parents. there are a couple of cases which are really relevant to this particular application. So I'll go through those and then we'll look at what the judgment says. But in the middle, I will show you a list of cases that were referred to during this court hearing, because I think it's important that you can see the full list. And then if you want to go away and research it in more detail, you can. And if you want me to do, an in-depth dive into all of the case law and what it said, I can do that if you shout out. But first of all, we've got Re B. Adoption jurisdiction to set aside, which happened in 1995, and the judge was the presiding judge was Lord Justice Swinton Thomas, but also there was the Master of Rolls, Lord Bingham, and at paragraph 251, he observed that the act of adoption has always been regarded in this country as possessing a peculiar finality. This is partly because it affects the status of the person adopted, and indeed, adoption modifies the most fundamental of human relationships, that of parent and child. It effects a change intended to be permanent and concerning three parties. The first of these are the natural parents of the adopted person, who by adoption divest themselves of all rights and responsibilities in relation to that person. The second party is the adoptive parents, who assume the rights and responsibilities of parents in relation to the adopted person. And the third party is the subject of the adoption, who ceases in law to be the child of his or her natural parents and becomes the child of the adoptive parents. And at 253, they went on to say, an adoption order is not immune from any challenge. A party to the proceedings can appeal against the order in the usual way. The authorities show, I am sure correctly, that where there has been a failure of natural justice and a party with a right to be heard on the application for the adoption order has not been notified of the hearing, or has not for some other reason been heard, the court has jurisdiction to set aside the order and so make good the failure of natural justice. I would have little hesitation in holding that the court could set aside an adoption order which was shown to have been obtained by fraud. So we can see here that the judge is talking about setting aside rather than revoking, and that is slightly different, because what they're saying is the order is null and void for some reason, so some failure of natural justice or some significant error in the law in the way that it was obtained. Which is slightly different to the circumstances here. And then we've got Re Webster and Norfolk County Council. That was in 2009. And that's a Court of Appeal case. Where at paragraph 149, the judgment stated this. This is a case in which the court has to go back to first principles. Adoption is a statutory process. The law relating to it is very clear. The scope for the exercise of judicial discretion is severely curtailed. Once orders for adoption have been lawfully and properly made, it is only in highly exceptional and very particular circumstances that the court will permit them to be set aside. And then at 163, it stated this: the question, therefore, is whether or not a substantial miscarriage of justice, assuming that this is what has occurred, is or can be sufficient to enable the adoption orders in the present case to be set aside. And then in Re K, Adoption and Wardship in 1997, an adoption order was set aside in circumstances where there had been, in the court's words, inept handling by the county court of the entire adoption process and failure to comply with the requirements of the adoption rules, procedural irregularities going far beyond the cosmetic, a fundamental injustice to the child since the wider considerations of her welfare were not considered, and no proper hearing of the adoption application. Lord Justice Butler Sloss said at paragraph 228 that there are cases where a fundamental breach of natural justice will require a court to set an adoption order aside. So we can see there that there are some occasions where a court can set aside an adoption order, but nobody in this case is saying that the adoption order was improperly made. They're saying it's broken down, and that's a very different set of circumstances. So I'm just going to show you the list, and I'll stay on each slide long enough that you can screenshot it if you want to go away and look at it later. Of the cases that have been decided at first instance in the High Court of the Family Division. But I'm not going to go through the detail at this point. So if you want me to, then please do ask and I will do a separate video. But it would be quite a long video if I went through them all, because there was a lot said. Okay. Right, now let's look at the actual judgment in this case, and it does go into a little bit about what the case is. So the first issue in the case that the judges needed to consider was whether there was a power to revoke the adoption order made under the Adoption and Children Act on the grounds of the welfare interests of the two children concerned. And the judgment says, in my view, I do not. The Adoption and Children Act sets out detailed and comprehensive scheme for the making of adoption orders. It is clear that those orders are intended to be lifelong and put the parent-child relationship in the same situation as birth parentage, which is self-evidently irrevocable save through an adoption order. The statutory scheme does cover revocation, but only in one very narrow category of case, which is legitimation. So the judge went on to talk about the position that was being advanced by the parties, and that was accepted by Justice Thies in the case of AX, and that was that inherent jurisdiction of the High Court can be used to to create a much wider category of revocation, namely where there is a welfare ground to do so, and the case is considered exceptional. So that's what AX held, was there's got to be a welfare ground, so it's in the child's best interest for the order to be revoked, and that there are exceptional circumstances. So it had those two prongs to it. And that the Court of Appeal has accepted a power to revoke under the inherent jurisdiction in cases where there has been a fundamental procedural irregularity, such as in the case of Webster. It's not entirely clear why those are not cases where an appeal against the order could not have been allowed out of time on the grounds of a breach of natural justice. So instead of saying we'll revoke the order, it would be you can appeal the making of the order in the first place, but late, basically. On one analysis, the orders were never validly made because of the procedural error, and therefore were either void or voidable. So revocation is only one legal mechanism that could have achieved the desired result. If the order is void in public law terms, then there would have to be some legal mechanism to set it aside. But in any event, the case law is binding upon the judge in this particular case, and there is therefore undoubtedly a category of case where the power to revoke or set aside an adoption order under inherent jurisdiction exists. So inherent jurisdiction is this safety net, which says that where there isn't a statutory provision, so there is an Act of Parliament that cover a particular area, and there is a need for the court to be able to make a decision in a particular set of circumstances, then you can look to the court's inherent jurisdiction. The flip side of that is if there is statutory provisions that deal with that area, then you can't rely on the inherent jurisdiction, and that's what we'll come on to in a moment. So the grounds of the application in the present case, according to the judge, were entirely different. They didn't relate to the validity of the adoption orders when made, but were based on a subsequent change of circumstances, namely the breakdown of the adoption. And the application was made solely on welfare grounds, essentially, and not on the grounds of any procedural irregularity. And therefore it falls outside of the scope of any of the binding Court of Appeal authorities. I've just been joined by one of the pooches. Chaos is my very favourite lurcher rescue. So what the judge is saying is, look, there are some Court of Appeal decisions which bind me, but they're different circumstances to this case. They're made on different grounds. They involve different legal arguments, so they don't actually bind me in this particular case. And the judge went on to say, in my view, it would be wrong in principle to use the inherent jurisdiction in the way being sought. essentially for the reasons given by Sir James Mundy in the case of FS v AM, albeit in a different context. And he goes on to say, as Sir John Donaldson said, the inherent jurisdiction is this great safety net to protect the interests of children, but it should not be used as an unprincipled and unlimited safety net. It is very tempting to use the inherent jurisdiction in this case because it's almost certainly in Y's best interest to revoke the adoption order, although the judge says, I'm less sure about X. However, if there is no power to do so, the issue of best interest doesn't arise. So a judge cannot sit there and say, look, it's clearly in the children's best interest to make this order, so I'm going to make it. They have to have a basis in law upon which to make that order. And what the judge is saying here is inherent jurisdiction doesn't give that permission base in these circumstances. And the judge goes on to say, it is clear from the case law cited above that the inherent jurisdiction cannot be used where there is a statutory scheme which covers the same ground. See the cases of FS and AM. But fundamentally, going back to the principle set out in the Kaiser Royal Hotels case, which is an older case. So that cannot mean that there has to be a statutory provision that covers precisely the same issue, or there'd never be a need to use the inherent jurisdiction. The point of the case is referred to is that where Parliament has created a comprehensive scheme, then the court can't use the inherent jurisdiction to add provisions into that scheme or to cut across the scheme and make a decision different to the powers that are provided by the scheme. The words cut across come from Lord Sumption in Reby, the case of Reby, where he was dissenting, but the point he was making there was not in itself a controversial one. So he effectively made the same point that Sir John Dyson made in the case of CPAG, where he says that the inherent jurisdiction cannot be used when it would be incompatible with the statutory scheme in place. So the judge went on to say that in the present case, the Adoption and Children Act is a comprehensive scheme which covers the entire process of legal adoption. And critically, in my view, it expressly deals with revocation of adoption orders, but only in a very limited category of case, that of legitimation. This must have been a deliberate choice by Parliament and fits with the overall scheme of adoption being a lifelong status. This must have been so this is basically the judge saying there is a statutory scheme in place, so inherent jurisdiction doesn't apply, essentially. So the entire tenure of the statute and the mischief, or to put it another way, the fundamental philosophy of the Adoption and Children Act is that it creates a permanent and irrevocable change of legal status for both adoptive parent and child. So you can see that the judge here is saying, look, if you then use the inherent jurisdiction to provide more ways to revoke that order, you're basically messing with the fundamental philosophy behind the act. You are expanding the areas for revocation, and so making it less permanent and irrevocable, which was what the philosophy behind it was. So he goes on to say, this is not a situation where it can be argued that Parliament simply didn't contemplate the problem which the inherent jurisdiction is being relied upon to address. Although adoption breakdown may perhaps be an increasing issue, it will certainly have been well within the contemplation of Parliament in 2002, and indeed when Parliament considered earlier adoption statutes. I did request counsel to do a Hansard search. So what the judge is talking about here is Hansard is parliamentary notes of what was discussed when they were deciding about whether or not to make the act. So I did request counsel do a Hansard search in order to be confident that there was no parliamentary material which supported the applicant's case. However, I am satisfied that the statute itself is clear in the sense that there is no wider support for any wider power of revocation. So the tests in Pepper and Hart are not met. That's another case. And therefore the parliamentary material is not admissible to the court. I note, for the avoidance of any potential misunderstanding, that the material wholly supports an analysis that the statute was intended to create an irrevocable status. So the judge there is saying, we can't look at the material during the judgment, but we've checked outside of the court and it supports the fact that there shouldn't be any wider power to revoke. And the judge goes on to say this, I am very conscious that at least 3 High Court judges have found a power to revoke an adoption order on welfare grounds. However, in none of those cases was the case law or the limitations to the use of the inherent jurisdiction cited in the judgments. There was no consideration on the restrictions on the use of the inherent jurisdiction described by Sir James Mumby in FS and AM. And in each of those cases, the judges referred to the power to revoke on welfare grounds only being used in exceptional cases. It might be argued that it is appropriate to use the inherent jurisdiction in something that is truly an exceptional case, because Parliament cannot have been expected to contemplate such a situation arising, and therefore, in a sense, it falls outside of the statutory scheme. However, in my view, such an argument would be wrong. Firstly, as I have set out above, the prospect of an adoption breaking down and it being in the welfare interest of the children to revoke the order is something that would have been well within the contemplation of Parliament. And secondly, it is not clear to me how truly exceptional the situation that arises in the present case actually is. The court ordered the parties to investigate the evidence on the breakdown of adoption placements. However, producing a solid statistical basis has proved impossible. The only statistics produced have a figure of 4 to 9% of adoptions breaking down, although it is not clear precisely what that means. In any event, this figure suggests that adoption breakdown is far from being an exceptional situation. So again, the judge is saying here, look, I understand why you might say the inherent jurisdiction can be used if it was truly an exceptional set of circumstances that Parliament absolutely won't have considered, but this isn't one of those. It's just a bog standard. The adoptive placement broke down. Sadly, such failed adoptions have become more common with somewhat older children being adopted, and with social media making it much easier for children and their birth parents being able to trace each other. This will be particularly the case where the children are old enough to remember their birth parents when they were adopted. Now, I understand what the judge is saying here, but what I will also say is in this particular set of circumstances, not only were the children potentially old enough to remember the birth parents, they were encouraged to see their birth mum by the adoptive mother. And I understand that she felt that they weren't settling, but I think therapeutic intervention first might have been more appropriate. And there is some research to suggest that during the settling in phase, it's better if children don't see their birth parents so that they do settle in and they understand this is their new forever home. Then you can go on to introduce contact with birth parents if it's deemed appropriate in that particular case. So there is currently a move towards allowing contact with birth families for adopted children. And I am very much on the fence about it, because I can see that it might reduce some of the trauma about not understanding why my birth parents don't want me anymore. And I can say firsthand from an experience with a person who is adopted how traumatic that can be, particularly as you get to your teenage years and you are trying to understand who you are and where you came from. But equally, I think it could be truly traumatizing to be pulled in two different directions by two sets of parents who you love dearly. So I think that there is probably a happy medium, and I think that each case needs to be looked at as its own individual set of circumstances, because I think different children will react differently to different setups, and it needs to take into account the children, the birth parents, and the adoptive parents when deciding what is appropriate. And I think that we need to make sure that we've got professionals who are trained well enough to be able to make those determinations and help families to make those determinations. And that training is going to have to be highly specialised. Otherwise, I think we may find ourselves in a position where we've got many more broken down adoptive placements. So let's get back to the judgment. So the judge goes on to say, it is submitted in this case that the exceptional circumstance is that it is the adoptive parent who is seeking to revoke the adoption orders. So you would normally get an application from the birth parents, potentially even the child, but more likely than not the birth parent. But in this case, it's the adoptive parent, and what they're saying is that's the exceptional circumstance. The judge says, I accept that this is likely to be unusual, but the principle of whether the court has the power to revoke an order on welfare grounds cannot depend on the nature of the applicant. It might well be the case that in circumstances where the children were the applicant, an adoptive parent would agree to the revocation if they thought that it was in the child's best interests. And then the judge goes on to say this: I can deal much more swiftly with the submission that section 31F(6) of the Matrimonial and Family Proceedings Act gives the power to revoke an adoption order. This has been a controversial provision where the breadth of the language used has led to considerable litigation and uncertainty over the scope of the power and whether it applies to final orders. So the judge refers to the following cases. So we've got CB and EB, with Justice Mostyn as the judge. And then we've got N and J with Justice MacDonald as the judge, and Re A and B, where Justice Cobb was the judge. None of those cases were adoption orders. However, the judge says this: I have no doubt that section 31F(6) was never intended to apply to the revocation of adoption orders under the Adoption and Children Act. Although the language is unconstrained, so on a pure linguistic approach, it could apply to such orders. There is nothing in the terms of the amendments to the Act that suggest it was intended to apply to such orders. It would have been little short of extraordinary for Parliament to have introduced a power to revoke adoption orders with no limitations or process, without including any further provisions. And again, that goes back to this concept that it should be an irrevocable and permanent order. So why would Parliament introduce a completely unconstrained power to revoke them? It's farcical, really. So the judge went on to say, a broad and unfettered power to revoke pursuant to section 31F(6) would be obviously contrary to public policy considerations in respect of the finality of adoption orders that are referred to in the case law set out above. Such a significant change to the statutory scheme for adoption would surely have included discussion papers and a broader public debate, none of which happened. Therefore, although the argument is an ingenious one, it is, in my view, clearly wrong. For these reasons, in my view, I have no power to revoke the adoption orders on the grounds of the children's welfare, and I therefore must refuse to do so. The judge then goes on just to give a little bit more and says, I do, however, wish to note that I accept, certainly in the case of Y, it would be in her best interest to revoke the order. She plainly finds the present legal fiction distressing, and the fact that it reflects neither reality nor her own sense of self deeply upsetting. This has been her position consistently for a long period. The position is less clear-cut in respect of X. I do not intend to carry out a detailed analysis of her welfare interests, given that I have found that I have no power to revoke the orders. There may be strong grounds for Parliament to create a power to revoke adoption orders in very particular circumstances, but that does not change the important constraints on the use of the inherent jurisdiction. Finally, I turn to the question of allowing both girls to change their names back to BM's surname. There can be no doubt that this is strongly in Y's best interests. I've referred above to the degree to which she feels distressed by her confused family identity, and has done for a considerable time. She strongly identifies with her birth mother, and has largely, if not wholly, rejected her relationship with AM. She has said very strongly that she wishes to be unadopted. I hope that by allowing her to change her name, I can at least in part help her in this respect. Although X is much less clear in respect of the adoption, she too has said that she wishes to change her surname. The application is therefore granted. So the judge basically found that there was no power to revoke an adoption order based on the children's welfare, unless there were very exceptional, extraordinary circumstances which would allow inherent jurisdiction to come into play. But just the adoptive placement breaking down was not enough. And that whilst they'd come up with an ingenious application in terms of this section 31F6 of the the other Act of Parliament, that was absolutely not appropriate to use in terms of revocation of adoption orders. Hope you found that helpful. If you do want me to deep dive into the rest of the High Court judgments that this judge said weren't binding on him, and in fact, whilst the power had been found by those judges to revoke orders, he wasn't particularly impressed with the findings that had been made. So I can do a deep dive into them, but I think this particular case will be the one that's the binding case going forward in any similar circumstances. So if you found it helpful, please, if you could hit the like button, because it will really help me to grow the channel. And if you can subscribe if you're not already a subscriber. I'll be dealing with cases ranging from case updates like this to more social work based information around child protection, and also some kind of more true crime based material as well. Thanks for watching. Look after yourselves, and I'll see you next time.